This is Rajeshkumar. Today we are going to see the topic adverse possession. Just I'm going to start with the introduction about adverse possession, and we are going to analyze one fantastic problem on the adverse possession. Let's start with the introduction. We all know that the law recognizes that once a person legally purchases a property, he is considered as a legal owner. This means the owner should be assured that the only way the property can pass to someone else if the owner themselves, whether he can choose to sell or gift or mortgage or lease the property. For example, if the owner takes up the mortgage and he fails to repay, then the mortgagee has a right to take possession of the property. Similarly, there is a special case. There are certain circumstances where someone who may be considered as a trespasser without any legal right to the property can still potentially claim the right of possession over the land, but he has to satisfy certain conditions. Intention. The actual intention of the adverse possession is, in summary, the law seeks to prevent the valuable land from being abandoned and unused by allowing others to take it over if the original owner he fails to assert their ownership over an extended period. Actually, the occupiers are known as the squatters. Initially, they are legally considered as trespassers only. However, if they can satisfy the specific legal requirements, they may eventually be able to claim a legal title to the property for themselves. Let's start with what the Limitation Acts 1980 provides. Under section 15.1, it says no action can be taken if it crossed or if the 12 years period is expired. Well, let's see what actually the Act says. No action shall be brought by any person to recover any land after the expiration of 12 years. The 12 years is very important. From the date on which the right of action accrued to him, or if the first accrued to some person through whom he claims to that person. Actually, the Act says after 12 years has passed, a squatter can claim the right to the property. Why? What is reason? It's because they have treated the land as their own for over 12 years and the legal owner had not objected. Currently, this law only applies to the land with unregistered titles. However, even for the land with registered titles, there is still recognition that a squatter can seek to have the title registered in their name if they can prove they have possessed the land for a sufficiently a longer period. Now we are moving to resolve a problem question on adverse question. Please read this question 2 or 3 times so that you will get a clear picture. Andrew was the registered owner of a farm, a private reservoir. It is set in the extensive woodland. There was a disused building in the wood near the edge of the reservoir where Andrew he left empty for many years ago. After he upgraded the reservoir's pumping station, but for many years Andrew had been looking for financial backers to redevelop the site as an adventure park. In 90, at Hansel, he discovered the building when he is going for the bird watching trip to a farm. And over the next few months, Hansel used this building to photograph wading birds on the reservoir. And later on, he decided it would be a good idea to renovate the building and live there. In 1992, took to staying there overnight at the weekends when he is working late on turning the building into a home. Later on, in 1994, he and his partner Linda both moved in, and Linda she cleared some of the trees and shrubs to create a garden, and she rebuilt the perimeter wall around the building. That is very important thing to keep the pigs from wandering off into the woods and eating the harmful plants. Andrew, the owner of the property, he was aware that Hansel and Linda had moved into the building, but he raised no objection. This is a very important point. That Hansel continued to live in the building until his death in 2000. So he leaving all his property by the will to Linda. In early 2022, Andrew finally gave up his research for the finance to redevelop the farm. He sold the registered title of the reservoir to Sally. Acting on the legal advice, Sally he wrote to Linda stating that she was content for her to remain in the property for the time being. So this is a very key word. It's a key word that for the time being is a key word. Please keep in mind. So the examiner is asking to advise Linda, and at the same time, the question to the examiner is asking how, if at all, would your advice will differ if Andrew had expressly told Linda that he did not mind her and her boyfriend using the building while he was seeking the finance. A third question is how, if it all, would your advice differ if the title of Afan was an unregistered throughout? So there are three questions. One is the first you have to advise the Linda. Second is you have to advise if Andrew expressly told he don't mind until he's seeking the finance. The third question is if it is an unregistered land, then how your advice will differ. So I just want to summarize the whole question in a single slide. First, Andrew was the registered owner. Second thing is that Hansel he discovered the building in 1990 and started using its photograph boards on the reservoirs. In 1992, Hansel began staying overnight. In 1994, he and his partner Linda moved to the building and they were doing vegetation and rebuilding the perimeter wall. And at the same time, Andrew was aware that Tansel and Linda were living in the building, but he did not give any objection. Tansel lived in the building until his death in 2000, so leaving the property to Linda. In 2022, Andrew sold this registered title of the reservoir to Sally, who told Linda she could remain for time. So let's analyze the question one first. How we are going to advise Linda. The first thing is the factual possession and the intention. Determining when the adverse possession might have begun. Tansel is using the building for photography and subsequent decision to renovate and live there in 1992 could mark the beginning of his factual possession and intention to possess the property adversely. So the Linda's action in 1994, she was clearing the trees and shrubs and rebuilding the perimeter wall, further solidify the factual possession and the intention to possess the property. So whether the Hansel and Linda's position was adverse, because the Hansel was using the building for photography and he's renovating and he's living there. This demonstrates his factual position and intention to process the property. At the same time, the Linda's action in 1994, she was creating a garden and rebuilding the wall. It's further demonstrate the factual position and intention to process the property. The key question is whether Hansel and Linda's position was adverse to the Andrews right as a registered owner. That's a question. The timing of the adverse possession. The claim is open to argument. The Tansel action in 1992 and the Lindos action in 1994 are considered as the start of the adverse possession. Then, the 12-year statutory period could be satisfied by 2004, after 12 years. However, the fact that Andrew was aware of the Tansel and Linda's presence on the property but did not object could complicate the issue of adversity. Sufficient exclusive physical control. Consider the Pi versus Graham case. Establish that the elements of factual possession and intention to possess must coincide for adverse possession to begin. The degree of factual possession required is it should be sufficient exclusively physical control over the property. If you see the Linda's action 1994, such as rebuilding the wall, could be considered akin to the enclosure, which is a relevant factor in establishing the factual position. That's a very important thing. The intention to possess the property adversely must be objectively shown, not just a subjective intent. When the actual factual portion arose, the eligibility for L to rely on the T's action. If Tanzil formed the intention to possess the property adversely in 1990, the question is when his factual portion, the exclusive physical control, arose. That's a question. The building work and the limited stays on the property during the time could be considered the start of his factual portion. If a Tanzil adverse portion is established, then Linda may be able to rely on it through the terms of a Tanzil will. When he is about to die, he gave a will to Linda. When the factual portion arose, if Tanzil found the intention to possess the property adversely in 1980, the question is when his actual portion, the exclusive physical control arose. The building work and limited stays on the property during the time could be considered the start of his factual portion. If Tanzil adverse portion is established, then Linda may be able to rely on it through the terms of the Tanzil will. Rebuilding the wall. Analyzing the Linda's action and their effect on the adverse portion claim. By rebuilding the wall, Linda's action could be seen as akin to enclosure, which is a relevant factor in establishing the factual portion. The fact that Linda rebuilt the wall to keep the pigs from staying does not necessarily negate the adverse nature of her portion, as long as other elements are met. The Andrew's failure to object to Tanzil and Linda's presence on the property could be seen as undermining the adversity of their portion. However, the Andrews' future plans for the use of the land do not necessarily destroy the adverse nature of Tanzil and Linda's portion as long as the other elements are met. This is a very important slide. Since 1995, if Linda had been adversely pursuing the plot in her own right, then she does not need to rely on the terms of Tanzil will. Otherwise, if Linda lacked the necessary intent in her own right, then only she may be able to claim the benefit of Tanzil period of adverse possession through the terms of his will. To summarize, the key issue to consider are the timing of the onset of the adverse possession, the elements of factual possession, and the intention to possess. The question of adversity in light of Andrew's awareness and lack of objection and Linda's ability to rely on the Tanzil's adverse possession claim. We already see this one, the factual portion, like she is living and maintaining the building since 1994 to until 2000, so continuing occupying, and she is removing the tree shrubs, rebuilding a perimeter wall. These are all considered as a factual portion. The intention to process is like renovating the building and making it her home and maintaining the surrounding land clear intention to possess. The actual thing is the expiry of the limitation period. Linda has been living in and maintaining the building for 20 years, from 1994 until the Transil death in 2000. So then continuing to occupy it thereafter. So this includes clearing the trees, rebuilding the perimeter wall, and using the building as her home. This demonstrates the requisite degree of physical control over the property. So therefore, based on the principle established by Pai versus Graham, Moran case, and Powell versus McFarland, the Linda has a strong claim to have acquired title to the disused building through the adverse possession. She should be advised to that she is likely to succeed if she make an application to the registered as a new owner. A discontinuation of portion by the paper owner. Andrews, the long-term lack of use of the building, and coupled with his unsuccessful attempts to redevelop the site, it suggests that he had a discontinued his portion of the power, part of the property, even if he maintained the ownership of the overall reservoir. As per the Buckinghamshire Country Council's Moran case, the fact that Andrew had a potential future purpose for the land does not prevent a finding of discontinuous of possession. Accordingly, the case law analysis suggests that Linda has a strong claim to have acquired the title to the building through adverse possession, despite the Andrew being the registered owner. She should be advised that she has a good prospect of establishing her claim if challenged by the new owner Sally. The key element of adverse possession are that the possession should be open, notorious, continuous, and exclusive for the required statutory period, that is 12 years. In this case, suppose she may argue that the Chancellor and Linda were in the possession of the building for 8 years only, from 1992 to 2000. So before the Chancellor death, it does not meet the 12 years requirement. However, as we see in the case law suggests that the unilateral license granted by the landowner can defeat a claim of, for the adverse possession even if the statutory period has been met. This is a third point of view of this case. It's Let's move on to the second question. How it all, if at all, would your advice will differ if the Andrew had expressly told Linda that he did not mind her and her boyfriend using the building while he was seeking the finance? Okay. The express permission from the paper owner would negate the elements of Linda's intention to possess the land to the exclusion of the owner. Without the necessary intention, she would be unable to establish the adverse possession requirement. In such a scenario, Linda would likely be considered a mere licensee or a permissive user rather than the adverse possessor. Her continued occupation would be with Andrew's consent, not against his wishes. Therefore, her legal position would be significantly weaker compared to the original facts present. Cases like Battersea, Freehold, and Simpson versus Fergus suggest that a clear declaration of intention to possess without the act of exclusion is not enough to establish the adverse possession. If Andrew had given a Linda permission to use the building, it would be harder for Linda to demonstrate the necessary intention to possess it adversely because her occupation would be seen as permissive rather than the adverse. However, the extent and the duration of her actual use of the property may still be sufficient to overcome this. It depends on the specific circumstances. The key point is this would, like Andrew had expressly told Linda that he did not mind her and Hansel use the building while he was seeking the finance. This would likely to create a unilateral license that would defeat any potential claim of adverse possession, even if the statutory period has been met, the 12 years has been met. The key factor is that landowner permission was explicitly communicated, and the squatter did not object or respond to it. That's a key thing. In the case of Colin Davison Windows Limited versus Kings Lane and West Norfolk's case, 2005 case, the court found that the implied license had been granted to squatters, where the vendor had made it clear that the potential purchaser would have to vacate if the sale did not go through. Similarly, if the Andrew had explicitly allowed Linda and Ansel to use the building while he sought for financing, this would likely defeat any claim of adverse possession, as the occupation would have been with the Andrew's permission. Another important case for the unilateral license is Buckler versus Buckler, where the license was granted by the landowner can defeat a claim for the adverse possession even if the statutory period has been met. This approach was approved in Collins, followed by Klaus development and the Smith case. Especially in the Smith case, the Privacy Council noted that they should not be interpreted as a resurgence of Denning's implied license theory, but rather it's a recognition that a unilateral permission that is not rejected or responded to by the squatter, it can potentially defeat their claim to the adverse possession. This is very important. Using the BP properties case, we can argue that the court held that the landowner could defeat an adverse possession claim by unilaterally granting license to the occupier, as long as the occupier did not contend to the license. So the another important point is if Andrew had returned to Linda in 2022 stating that he was concerned for her to remain the property for time being. This could be interpreted as granting Linda a license. However, the passage did not indicate whether Linda accepted it or contested this purported license. Here comes two options. The final outcome it would depends on whether the Linda accepted the license granted by the Andrew statement, or if she contested it and maintained her adverse possession claim, then her occupation would no longer be adverse. She would likely not to be able to claim title by the adverse possession. If she contested the license, then her adverse possession claim may still succeed, as a unilateral attempt to grant a license would not be sufficient to defeat the adverse possession. In the actual scenario, if you see where Andrew was aware of Tanzil and Linda's admission, but did not expressly object, the situation is more ambiguous. The case law suggests that the unit license can still be inferred even without explicit communication. Suppose if the landowner's action or inaction indicate that do not object to the occupation. However, this may be a more nuanced analysis. The court may consider other factors such as the nature and the extent of occupation to determine whether a valid unit license was created or not. Let's summarize the answer for the question two. In summary, the case law on inert license suggests that even if the statutory period of adverse possession has been met, a landowner's explicit or implicit permission can still defeat the squatter claim. The specific facts of the case, including the nature and extent of the landowner's knowledge and communication, will be crucial in determining the outcome. In summary, if Andrew had expressly granted the permission, as that would be likely to create a vendor purchase license and defeat any adverse possession claim. However, in absence of such express permission, the outcome depends on whether Linda accepted it or contested the purported license granted by Andrew's 2022 statement. Let's move on to the third question. How, if at all, would your advice differ if the title to a phone was an unregistered throughout? Under the Limitation Act 1980, the adverse possession for 12 years would extinguish the paper owner's title under the sections 17, and it's allowed Linda to apply for registered title under section 62.4 and 62.5 of the LRA 2002. These changes introduced by LRA 2002 was for the registered land. It would not apply. Therefore, my advice to Linda would be that she has a strong claim to the property through adverse possession, as the register would not conclusively determine the ownership. So overall, the key factors are length of possession, owner's knowledge, lack of objection, whether the land was registered or unregistered. The case law provides the framework for evaluating the Linda's. So the main difference would be in relation to the statutory framework. Under the unregistered system, the Linda's adverse possession claim would need to satisfy the requirement of Limitation Act 1980, as we seen earlier, particularly the section 15 and 17. She would need to demonstrate 12 years of continuous adverse possession to the extinguished adverse title and acquire the property. So the Powell versus McFarlane case and the Pye case would still be highly relevant in answering the factual and intentional aspects of the Linda's question. The unregistered nature of the title would not fundamentally alter the substantial legal analysis, but would simply require consideration for the different statutory regime. So overall, the advice to Linda is likely to be similar in both registered and unregistered scenarios, as the core principle of adverse possessions are applicable in both the cases. Here, the main difference is that the Linda would need to apply to the land registry to be registered as a new owner, rather than making a claim against the registered title holder. That's the only difference. As per the Purbury versus Hankey case and Palfrey case would still be relevant in assessing whether Linda's use of the property amount to adverse possession. The same factors around her physical control of the property, her intention to possess, if you consider the overall, the assessment of Linda's claim is substantially the same, regardless of whether land was registered or unregistered. So, in these two slides, we are going to conclude overall that Hansel, first point is that Hansel took the portion of disused building in 1990 and began using it, eventually moving in with Linda in 1994. So, the continuous portion for the next 10 years likely to establish their claim for adverse possession under the section 15 of the Limitation Act 1980. So even though the property was registered to Andrew, the case of Paul versus McFarlane and Bosey and Davis established that the register is not conclusive and adverse possession can still be claimed. Andrew was aware of Tencel and Inda's equation but did not object, so which supports their claim under the principle of Kubrick versus Hankey case and Hanslow case. When the property was sold to Sally, she explicitly stated she was concerned for Linda to remain for time being. That's a key word. So further, it's strengthening the Linda's position. Therefore, I would advise Linda that she has a strong claim to remain the possession of the property based on the principles of adverse possession. So the new criminal offense under the section 144 LASPO Act 2012, it does not appear to prevent her from relying on the adverse possession. The rules as per the case R versus Chief Land Register. So this is the overall conclusion of all the three questions. Thank you, my friend.